As was stipulated in the creation of the Commission, the CIC was only to be in existence for 5 years. That term ends Tuesday. And the Commission is tasked with implementing the Constitution, make their humble exit with both achievements under their belt and cognizance of challenges they have faced. But 5 years down the line comes this acknowledgement that there is more to be done in line with the supreme law of the land.
This is the moment that Wanjiku, as the owner of this constitution, must step forward.
The Commission notes that there was evident intimidation and threats by other arms of government in its work, particularly in challenging the manner in which the National Assembly sought to enact legislation designed to enhance their salaries, allowances and terms of service and to facilitate their control over CDF.
More often than not, Parliament appears to forget or ignore that it is a creature of the Constitution and that it must therefore at all times act in accordance with the Constitution and on behalf of the people of Kenya. We have too many instances of Parliament acting like it is an extra-constitutional body.
The CIC end-term report provides recommendations for amendments by identifying provisions or articles of the Constitution which are silent but which, if included or amended, would enhance implementation of the Constitution. For instance, it recommends reducing the number of constituencies to 150 down from 290 to give a total of 225 MPs and have wards set at a maximum of 750. It further recommends an amendment to separate the holders of the Chief Justice and Head of the Judiciary, Supreme Court Judge and the President of the Supreme Court and the Chair of the JSC appropriately to remove conflicts of performance. CIC has, among other things, taken stock of pieces of legislation meant to be enacted within 5 years as required under the 5th schedule. Those pending are legislation in respect of culture, land, and labor relations. CIC further recommends a high educational requirement threshold be set for those seeking elective office, as did IEBC that proposed the MCAs and MPs should be degree holders by 2022.
If you think about it even logically, today we have a law that provides that governors and their deputies must hold degrees. But then members of county assemblies whose primary role is to oversight those governors and their deputies are not required to have the same educational standards. Logically, there is obviously something wrong there.
Jackie Maribe, Monday Special.